a person who arrives at the borders of a state cannot be sent back to any state where he or she would suffer persecution on the basis of race, religion, nationality, membership of a social group, or political opinion, until the state has determined the application. So that's the idea of non-refoulement. Now it's shared between the Refugee Convention, the Convention Against Torture, the Convention Against Enforced Disappearances 2006, the EU Charter on Fundamental Rights, and of course lots of other regional provisions. But what does it mean? What it means is that there is a duty on states to decide whether someone is a refugee or needs international protection, so is at risk of torture or enforced disappearance, before they can send the person back across the border or refuse to admit them. So what happens in Europe after 1989, this is an end of Cold War scenario, there's a surge in the number of asylum seekers in Europe, people saying, I'm a refugee, I'm at risk of torture. We have the Balkan Wars, we have an awful lot of people moving around. There's a huge backlog that builds up. And in Europe, we create this administrative category of an asylum seeker. An asylum seeker is not a term which exists anywhere in the Refugee Convention, and it does not exist in any of the human rights conventions. Okay? It is not part of international law, it's nowhere. What it is it's an administrative tool which European states wanted between the moment when someone turns up at the border and says, I'm a refugee, or I need protection against torture, and the time when the authorities have created the file, have determined the case, and then they decide either the person is a refugee or a beneficiary of international protection because they fulfill the conditions, or they're not, and they never were a refugee, and they're no longer entitled to anything. So it's an administrative category to deal with that interim period while the state is making its decision. Under the Refugee Convention, the idea was states would make decisions really fast and there was no need for any interim period. And anyway, a refugee was a refugee from the moment that he or she fulfilled the conditions of the convention. So we have this category creeping in. So then non-refoulement becomes the key of what happens at the border. So for the Refugee Compact, it's non-refoulement. And for OHCHR and the Special Representative, it becomes situation of vulnerability at the border. So when someone turns up and says, I'm vulnerable at the border because I'm going to be tortured, or I'm vulnerable at the border and I want non-refoulement because I'm going to be persecuted if you send me back, or I'll be sent back to persecution, to a country where I'll be persecuted. You have a duty on states to determine the application before putting that person at risk of non-refoulement or of the situation of vulnerability at the external border. So what you have in the COVID-19 period, as we've seen very much in Europe, but around the world, is you have had the closing of external borders, this expression of sovereignty, the idea that somehow closing borders will be good for controlling a pandemic, something which has been refused by WHO, it's been refused by the UN Human Rights Council, it's been, you name it, under the international institutions, everybody says borders, closing borders does not deal with pandemics, and it doesn't help. People who arrive at borders and who are sick need to be put in quarantine. And that's what stops pandemics. It's not pushing them back across the border and having them build up on the other side of the border and propagating the virus. So we have the question of the compatibility of this closing of borders with the principle of non-refoulement. So when we had on the 3rd of March, the heads of the EU institutions who went to the Greek-Turkish border and applauded the Greek border guards for holding the line and not allowing anybody through the border, UNHCR was placed in a very difficult position because that was an obvious example of incompatibility with non-refoulement. The border guards had to ask those people, do you need international protection? And if they said yes, then there could be a border procedure. It could be a quick procedure, but they would have to do an investigation on an individual basis on whether the person needs protection. And that's what the state's duty is in respect of refugees at the border. Borders don't change the duty under the Refugee Convention or under the Human Rights Convention to the duty of states to examine a claim in a fair procedure. It can be a quick procedure, but you have to have a procedure, and the individual has to be able to explain why he or she has a fear of being returned to the place where they've come from. You have this fairly clearly stated in EU law. It's in the Schengen Borders Code. It says, Article 3b says that it's without prejudice to the principle of non-refoulement. So you cannot apply the Schengen Borders Code at the external border of the EU when someone asks for asylum at the external border. It's specifically excluded from the Schengen Borders Code. Then you have the Procedures Directive, the Refugee Procedures Directive, Asylum Procedures Directive, where there's special provisions for determining applications made at the border. So where people apply for asylum at the border, they can be held in reception centers at the border, and they can be subject to faster procedures, but those procedures must include an opportunity for the individual to make an application. And then they're kind of the let-out clauses. If the person's coming from a safe third country or a safe country of origin, then their applications are manifestly unfounded. So a decision can be made rapidly, but the individual must have the possibility to make the claim. And here, what we saw on the 3rd of March on the Greek-Turkish border was a very substantial claim by EU leaders that Turkey is a safe third country for these people. They were not Syrians, they were Afghans, they were Iraqis, countries which have a pretty good recognition rate as refugees in the EU. And the EU officials were saying, no, Turkey is a safe country, a safe third country for these people. But you have an awful lot of international organizations, including UNHCR, questions about how safe is Turkey? Does it not send people back to persecution? And you have a really very active debate, also including the courts, saying that no, Turkey is not safe for asylum seekers from some countries, and there must be a consideration of their application. So then we have on the 17th of March, the EU makes a statement about how we're going to close the external borders of the EU for non-essential travel. These will be Schengen borders because the EU does not have competence over the external borders of non-Schengen states. So first of all, we have the Schengen states, which excludes a number of EU member states. So Bulgaria, Cyprus, Romania are outside of Schengen, as well as Ireland, which is a voluntary exclusion. And Croatia is standing there on the edge, almost in and almost out, but not quite either. And then you have the Schengen Non Eu States, which is Norway, of course, Switzerland, Iceland, Switzerland and Liechtenstein. And you have those which aren't covered by the Common European Asylum System, but are part of Schengen. So you have a complete mess in EU law. Every time anybody has to deal with the Schengen border, it's a complete nightmare because of these categories. But in all of them, they're all bound by the Schengen Borders Code, and there's an obligation not to refoul someone to a place where they would suffer persecution. So then the Commission sends out guidelines on the 16th of March, and the guidelines to the border guards of the Schengen area make no mention of the non-refoulement requirement. Even though it's in the Schengen Borders Code, which is a regulation, it has to be applied at the external border. Border guards are supposed to know about it. The guidelines make no mention. The Commission's communication to officials on temporary restrictions say that they're not to affect persons in need of international protection or other humanitarian reasons. So we have, between the EU guidelines to the border guards and the EU guidelines to the asylum authorities and the immigration authorities, we have, on the one hand, the inclusion of non-refoulement. On the other hand, to the border guards, forget it, there's nothing for them. Then we have a problem of the intra-Schengen borders. There are not supposed to be any border controls between the intra-Schengen borders. And of course, the big irritant there is asylum seekers. And there's the Dublin 3 system, whereby asylum seeker who seeks asylum in one member state is supposed to be the responsibility of that member state, and they're not supposed to be, if they move to another member state, they're supposed to be sent back there. And of course, the system doesn't work. It's completely crazy. 3% of asylum seekers in the European Union are ever, in fact, moved from one member state to another under Dublin 3, though probably about 80% of them come within the terms of Dublin 3, but it's just completely unworkable. So then we have the 26 Schengen states that are busy fighting about intra-EU borders. They're never supposed to have intra-EU borders, but there's a temporary let-out in the Schengen Borders Code where they can introduce temporary intra-Schengen border controls. And 14 states use that on COVID-19 grounds. 3 states used it on foreseeable COVID-19 grounds. So you have 17 out of 26 who think that border controls among Schengen states are going to be useful for COVID-19. And you have the rest of them who think this, shoot me, this is not going to help. This is not the way forward. So you have a huge divergence of opinion among state authorities on whether intra-Schengen border controls are useful, let alone extra-Schengen border controls. And then you have the problem about what do you do with your asylum seekers? Asylum seekers in the Marrakesh Convention, or refugees, or rather migrants in the Marrakesh Convention, detention is always supposed to be a last resort. Objective 13, Refugee Compact, alternatives to detention, paragraph 515. So in international refugee law and international human rights law, detention can only be used if there is an objective reason why the person cannot be left free. In practice, many EU states provide reception centers where asylum seekers go and they're housed and they're given food and the children are given schooling and they get health conditions in these reception centers, which are open. Problem, COVID-19, the practice in quite a number of EU states has been to transform these reception centers effectively into detention centers. The doors are locked to the rooms, and people are just stuck there. They're no longer in reception, they're now in detention. And there's been no individual consideration about whether there is a need for them to be in detention. This is just on public health grounds. There'll be other asylum seekers in every member state who will be living in the community. They won't be subject to detention, as are the ones who are in the reception centers. Then you have the problem of the migrants who are subject to expulsion decisions, who are in detention. And in international human rights law, the state power to detain a migrant is limited to the purpose of expulsion or preventing an unauthorized entry into the state. But here we're talking mainly about expulsion, but the legality of detention only exists if there is a real possibility of expulsion. With COVID-19, we know from the Commission, 90% of flights, ferries, trains, and buses in the EU have stopped. Therefore, there's no possibility of expulsion. Therefore, why there is no longer a legality for the detention of migrants subject to expulsion decisions in the EU. Not that everybody's done very much about that. Then we have the question of procedures. The only way that a refugee can move from being a suspect asylum seeker to a recognized refugee is by explaining to a public official why he or she fears persecution. The same is true under the Convention Against Torture, the Convention Against Enforced Disappearances. The individual has to explain to someone why, what it is about his or her situation, which means they need international protection. That is incorporated into the importance of the personal interview. It's in the Procedures Directive, it's in the Marrakesh Compact under paragraph 27C, it's in the Refugee Compact, paragraph 62. The Refugee Compact is less clear, but we see that in quite a number of EU states, there's been a complete suspension of interviews on COVID grounds. Austria, Cyprus, Netherlands, those are just 3 examples. The problem is that means there's no way for the asylum seeker or the person who is a refugee but is trying to get status to be able to explain why he or she needs protection and to move from this, the not very good status with very limited rights of an asylum seeker under the common European asylum system to being a recognized refugee and having the right to work. Not that, well, I mean, there are jobs out there. Lots of refugees would like to work and are qualified to work, for instance, in the health service, where we have huge shortages of qualified staff. But without the personal interview, nothing happens. They're stuck there. Other member states have continued to interview, and they use online procedures or they use masks in the interviews, etc. So you have a problem about the validity of the suspension of the interview, which would allow people to move forward. And then you have some member states that have just suspended everything. They're not doing anything. France and Greece are 2 examples. So nobody can do anything. A counterexample, which is a very positive example, is Portugal, which as soon as lockdown arrived in COVID-19 times, in the middle of March, the Portuguese authorities stated that everyone who had an application pending for any kind of immigration status or asylum status in Portugal would get a work and residence permit, equal access to health conditions, to housing, etc., as Portuguese nationals. And they allowed everyone who was not a threat to national security out of detention. So they said, the fact that our authorities are unable to make decisions over this period because of COVID-19 must not prejudice the rights of these people to their rights if they're refugees, to their rights if they're migrants. They must be entitled to equal treatment with Portuguese nationals in order to ensure that the propagation of COVID-19 is not extended, developed, or occurs in a discriminatory manner running through detention centers or reception centers. And there I'm going to stop, and I'll leave you to ask questions. I think I've really just run through a number of the big legal issues and how they play out in the domestic regime, and how we've been looking at them in the context of the COVID-19 scenario and the 2 blogs that we've written and that Mari has put up. Thank you very much. I'm going to stop sharing my screen now.
Thank you very much, Elspeth. That was a very interesting presentation. If anyone has questions, they can type their names in the chat and we'll just take it from there. I see that there are a couple of more people that have joined us. So Hakan, seems like you're up first.
Thank you very much, Elspeth. All these differences between these countries, Portugal, France, and Greece, it's very interesting to see these differences. And it's also very interesting to see that the countries are so easily breaking the international law by acting in different ways. But why do you think is this difference between different countries? Do you have any theory or hypothesis about that?
Well, it's a really good question. And that's why I'm so interested in this project, because we're trying to figure out how come Portugal can, have such human rights-based policy, and yet France and Greece behave like asylum seekers and migrants are a threat to their existential being. And I think it's one of the things that we really need to look at. One of the things that I find very interesting, and I'm not sure how to theorize this, is that the Secretary General of the UN and the head of the IOM are both Portuguese nationals of a similar generation, Guterres and Vitorino. Vitorino, of course, cut his teeth in the EU, Guterres in UNHCR. And you see Portugal being a beacon in international organizations, not just in what happens in Portugal, but in the way in which their nationals become part of the international system in a way which is really interesting. In France, I was asked recently by a German colleague who'd seen a program on television about police violence in the suburbs, about was it true that there is a problem in France with police violence in the suburbs? And I had to say, well, yes, we've had a number, in France there have been a number of instructions to police in the period of the yellow jackets, where the police préfet were given huge powers to authorize their police officers to use infinitely more violence than they had been entitled to use before against demonstrations. And so in the 2 years of the Gilets jaunes, you had the police shooting protesters with stun guns, which were used in a way which cut off their hands, and a number of people were blinded. So we had a real violence which really became much greater in May 2 years ago. Then we had the strikes from November 2019 until January 2020. And again, the demonstrations were met with this increased violence. And my friends in Germany said, well, why does nobody denounce this? Why is nobody, why are the politicians allowing the infiltration of the police authorities by the extreme right? And I had to think about it, and I had to talk to a number of colleagues in France about it. And the answer that I was given, and I don't know whether it's correct or not, is that the political parties in the center are terrified of entering into any debate with the very powerful police union on law and order, because they think that this will just be a gift to Marine Le Pen and the Rassemblement National, and Rassemblement National will then win the next presidential elections. So they move to the right. They don't engage with the infiltration of the police by the extreme right or with police violence, because they're afraid this will assist the far right. And I think it's a very interesting argument. And I think my friends in Germany were asking me about this because of the quandaries which their struggles with Alternative for Deutschland are presenting to them. But I don't know whether that answers your question. But I think that there are knee-jerk reactions and scapegoating asylum seekers and migrants is one of the classic forms of seeking to consolidate far-right opinion.
It answers my question, and I'm also very happy to learn that it fits in my cleavage theory as well. You have all this extreme right wing pressing the government to act in a specific way, and yes, it's politics and not law that works in this. Thank you very much.
Okay, so it seems like Dario is up. So go ahead, Dario, your question.
Thank you, Mari. Thank you, Elspeth, for the presentation. My question is on a specific point you raised at the beginning. So you mentioned the OMS criticizing the decision to close the border as ineffective. the same policy was also criticized by South Korean philosopher Byung-Chul on an editorial to the El País. He reported that South Korea didn't close the border, if I'm correct, and still they were managing the epidemic very effectively. But my question is, how much weight does this empirical question have? So let's say let's imagine, for the sake of argument, the OMS is wrong and the epidemic can, the closed borders can be effective to slow the epidemic. Does it change it with respect to non-refoulement according to your legal analysis perspective? Thank you very much.
Okay. I've worked with some other colleagues on the state sovereign knee-jerk reaction, closed borders in respect of any threat. And I've written in the past on the closing of intra-EU Schengen borders on the basis of terrorism grounds, which a number of states have done. So I'll leave that aside for the moment. But it doesn't matter whether you have opened or closed borders. Every state has an obligation of non-refoulement. So you can close your border if you're a signatory state of the Refugee Convention. If you're not, you're not captured by it. But if you're a signatory of the Convention Against Torture, which almost the whole world is, the only convention more ratified than the Convention Against Torture is the Convention on the Rights of the Child, you cannot close your borders. If somebody stands at your border and says, I need protection against torture, you have to let them in. So it doesn't matter how open or closed your borders are, your non-refoulement duty requires you to determine the application. And remember, in the EU, in a normal year, EU is an area of about 450 million people. It's 27 member states with the associated states, and they're about 500,000 asylum seekers a year. And the EU admits to across the external border of the EU every year, according to Frontex, over 320 million people. So we're talking about a tiny number of people who seek asylum at the border in comparison with completely ordinary, normal, not in COVID-19 times, but in normal times, arrival of over 320 million people a year. So our arguments about efficiency don't work. Our efficiency at the border, our arguments about protection don't work. Our arguments that a knee-jerk state reaction to enforce border controls will only result in a breach of the obligations under international protection. The judges will come down on them. And within the member states in the EU, why is there such a difference of opinion? I think it depends on how strong different parts of the administration are. I think you have to go into the problem of disaggregating the state. So if you have a fairly weak interior ministry, perhaps this is a state where in our lifetime it lived under a dictatorship or authoritarian regime, Central and Eastern Europe, the Southern Mediterranean states, where the interior ministries were extremely complicit, and therefore they've come out of that period quite weak. You have other ministries like social ministries, which have a much stronger voice and say, this is not the solution, or the health ministries saying the solution to a pandemic is quarantine and health services. It's not differentiating between citizens and foreigners.
Thank you very much.
Okay, so Edil, it's your turn. Go ahead.
Thanks a lot, Elspeth, for your presentation. It was very rich. I have a question regarding the absence of any reference in the Marrakesh Compact to the non-refoulement principle. I haven't realized it. It's really interesting. Also, your remarks about how in the Marrakesh Compact, the concept of the situation of vulnerability was used instead of a non-refoulement principle. And I'm wondering if you could expand a bit on that, and what do you think of, what might be the effects of these of this understanding of this approach? Is it a watering down of the non-refoulement principle?
I mean, it's a really good question, Adil, and it's always very nice to see you. I think when we were talking to the actors, when we were, doing our indicators and working on the human rights of migrants and engaging with the negotiating process, the colleagues that we spoke to in OHCHR and in the Special Representative's office were disappointed that UNHCR would not allow them to use the word non-refoulement. They really wanted to use it. They thought it would be a really good passerelle between the two compacts. But UNHCR was absolutely adamant that they were going to have a monopoly over non-refoulement, even though non-refoulement is, as I mentioned, it doesn't belong to them anymore. It belongs to international human rights law. So, but I think that the reason that UNHCR won that battle was because it took place very early, before Louise Arbour was appointed. When OHCHR was trying to battle its ground, IOM was battling its ground as well, but it also had a director, Swing, who was going to retire very soon. So you had a lot of institutional uncertainty around Marrakesh, whereas UNHCR was just like an incredibly well-oiled machine on the refugee compact. And I think that now we look back at it, now we look at the two compacts and we compare them, we see how different they are. They're written in a completely different style, completely different concepts and content. And I think a lot of us as observers are fascinated by how much more protection friendly the Marrakesh Compact is than the Refugee Compact. That the Refugee Compact, in terms of refugee protection, is a pretty sad affair. Even the references to non-refoulement, there's only one, saying it's the cardinal principle, but then they never develop on it. And then they go off into this, host communities are having too much trouble, and let's try and make the life easier of states. Again, this goes back, I think, to our last seminar about whether the UNHCR's approach that the compact should be about agreement among states and about cooperation among states is not inherently problematic to the correct application of the Refugee Convention itself, which requires states to defy one another. To say, I'm going to recognize this person as a refugee, even because that means, even if that means I'm saying that you, United States of America, persecute your citizens. And this was common. I mean, in the 1990s, a number of British citizens were given refugee protection both in the Netherlands and in Canada on the basis of the inability of the UK authorities, or the unwillingness of the UK authorities, to protect them in Northern Ireland. But it's very in your face. And you have to accept that no refugee protection is not about cooperation. And so the Refugee Compact is all about cooperation. And in fact, the Marrakesh Compact is much more about people in vulnerabilities. And yes, we want countries to work together. We have to share responsibilities, but individuals have rights. And I think that's really the tension that we're looking at in the two.
Thank you.
Thank you very much. Does anyone else have questions? You can either raise your hand or just.
Yes, may I pose a question? Thank you.
Go for it.
Thank you. First of all, thank you for the presentation. Very, very rich. I have a question on the principle of non-refoulement in the specific context of maritime areas. The non-refoulement applied to the maritime areas, the Mediterranean, for example. How to connect this principle with, for example, the management of rescue and search and rescue operation, and what are the implications of the application of this specific principle in the maritime areas? Thank you.
Oh, Francesca, this is such a huge question. I've actually, at the moment, I'm looking at serious crimes in the context of migration. So I've been looking at the prosecutor of the International Criminal Court and the process in respect of Libya, but also implicating officials in the EU and in the member states for creating the conditions of crimes against humanity in Libya through the ceasing of Mare Nostrum, knowingly putting into place a system of Triton which was not going to fulfill the needs, putting into place Operation Sophia as a military rather than a civilian process, which then creates this phantom organization of the Libyan Coast Guard, which is actually a bunch of pirates with no proper authority, which are the objects of the EU's funding and the bodies which are resulting in the kidnapping and torture, etc., of migrants in Libya. So this is a very, very topical issue. We have, of course, the European Court of Human Rights and the decision in Hirsi, and then the decision in Califia, and then ND and NT that we're all still chewing over. So we have a certain, well, we have a lot of courage from the Court of Human Rights in Hirsi. Then we have, you know, they're being bullied by interior ministries of some member states in Califia. And then ND and NT, and we're all saying, like, where does that go? You know, where does this take us? Now, the two examples were people who had an asylum, an opportunity to make an asylum claim in Spain, and one had been rejected and the other didn't want to make the claim. So the facts were very specific in ND and NT, and I don't think that we can expand on them. But and then as the complaint to the prosecutor of the ICC shows, the criminalization of NGOs doing rescue as part of the creation of the conditions of crimes against humanity, which are, in respect of which there is criminal liability for both EU and member state officials. So I'm very aware of the problem, and I'm very, I find it astonishing that this has gone from being a human rights issue in Hirsi to being an international criminal law, crimes against humanity, against EU officials question. I mean, and we have 11 UN special rapporteurs who have intervened, saying that there is a profound problem of human rights compliance in respect of the policy of non-entrée and pushback. So we're looking at the international community, looking at Europe and saying, you are not complying with our international standards. I don't know where all this is going to end up, but it's very ugly. Who would have thought 10 years ago that the ICC prosecutor would be facing, looking at named individuals as architects of a project to create torture and persecution? It's very worrying.
Thank you. Thank you.
Thank you, Francesca, and thank you, Elspeth. I haven't received any other questions in the chat. Still possible to ask questions if you're Hakan, who's on it. Go ahead.
Okay, one last question. I don't know much about the legal cultures of different countries in Europe, but might that be a factor that can be used to explain the differences? Legal cultures might be quite different.
I think certainly we have a question of where do we have the embedding of refugee and human rights law into national law in a really durable manner. But then that doesn't really explain Portugal, where you have quite weak institutions in migration asylum, but very strong political will to comply with international human rights law. And then you have an example like Hungary, which we were just looking at an opinion from the EU Court of Justice about the abysmal conditions of reception of asylum seekers in abandoned barracks in the middle of nowhere, where the EU Court of Justice is saying this is inconsistent. But Hungary, of course, has a very strong tradition of legalism, as do quite a number of the Central and Eastern European countries. So I'm not sure that we can draw conclusions from the strength of the legal institutions per se. I think we need to disaggregate a bit further the state between who has power, who is interested in caring for the people who live on the territory. I mean, a lot of academics always put forward the question, well, was this a country of migration? So, oh yes, Portugal, yes. Well, they have this big Portuguese diaspora, from the 1960s. So of course they're nicer. But then that doesn't explain Italy, that has an even bigger migration diaspora, across the world, in the US, in Australia, in the rest of Europe, and yet is very unwilling to show a lot of solidarity, at least at a governmental level, to questions about vulnerability of migrants and non-refoulement. So I'm not sure that explains things, but I really do think we need to think seriously about disaggregating the state and looking at what kinds of institutions have authority. For instance, equality commissions.